Silva and Heselton.
Very pleased, Your Lordships. I appear on behalf of the appellant. Mr. Learned friend Mr. Paget appears on behalf of the respondents. My Lords, I hope that you've had the opportunity to consider the skeleton arguments.
We have indeed, and we've read the two judgments below.
I'm very grateful for that. This appeal centres on the question of whether or not my client is entitled to be remunerated for her work in the administration of the estate, in addition to her right to be compensated for expenses properly incurred. And that, in my submission, begins and ends with the terms of the charging clause in the will. And without further ado, I propose to take you to that clause. You can find it in either of the judgments, but perhaps it's better to start at page 80 of the appeal bundle behind tab 11, where the clause itself appears, albeit not in the clearest of forms. There are, as you will have seen from the judgments below, two typographical errors. It's agreed between the parties that those are of no consequence. To begin, my trustee shall have the following powers in addition to their powers under the general law. And then subparagraph G, it's worth breaking this down into parts. For any of my trustees who shall be engaged in any profession or business, pausing there, there is nothing in the clause that supports what my learned friend says, that the professional business must be one valuable to the estate or carrying expertise particularly relevant to estate administration. I continue, and to be paid in priority, etc., all usual professional and other fees, and to retain any brokerage or commission for work or business introduced, transacted, or done, and importantly, or time spent. So we will, if I can then simply break it down further, all usual or professional or other fees is the wording that the learned judge below seized as indicating that these fees must be, that the work done must be work which would attract a usual professional or other fee. That is, of course, in my submission, not expressly what the clause itself says. Indeed, it is not tied to an item of work. And that's why I emphasise the words or time spent that appear in the clause. The clause is deliberately framed in very wide terms. It is not simply work done, it may also be time spent, or indeed business introduced. I continue. In connection with the administration of the estate, that of course is a necessary restriction on the scope of the charging clause. Administration of the estate or trusts, powers, etc. And then, in my submission, most importantly, what I will call the chapel extension, including work or business outside the ordinary course of his profession and work or business, which he could or should have done personally had he not been in any profession or business. My lords, it is those words that I say demonstrate why the conclusion reached by the judge below was wrong. You cannot have a usual professional fee for work which falls outside the ordinary course of your profession or business. Now, those words are not inserted by accident. And with your permission, my lord, I would take you on a brief history lesson.
Just before you get to that, can I just ask a very simple question?
Please.
Going back to the phrase all usual, professional and other fees, would you accept that the word usual qualifies both professional and other?
Yes. Yes, indeed. They must. And my lord, I say that the words are chosen carefully. The testatrix could, of course, have simply prescribed a fee, an hourly rate. She could have simply said a reasonable fee. But and of course this is taken from an earlier precedent. These words have been in use for centuries by now. It is tied to what the person, the professional or the businessman, would usually charge for their time spent. But it is not prescribed to a particular kind of work. It is what they would usually charge.
So here, assuming you're correct and the appellant can charge her usual professional fees,
Indeed.
what are, or by reference to what usual professional fees is she charging? Is it as a cafe owner in Harrow, or?
My lord, the usual professional fees that she charged were by reference to her property management business.
Not on the evidence we've seen.
Well, my lord, I think I can take you through the evidence in particular. It's behind, actually, only a few pages on in her witness statement. So paragraphs 9 to 11, page 85 of the hearing bundle. And the evidence, my lord, I readily accept could be considerably more detailed than it was, and that criticism was made by both of the judges below. But from paragraph 9, she describes what she describes as her debt recovery companies, which themselves retained a firm of solicitors. That firm, in paragraph 10, is the firm of which she was the practice manager from 1992, so long before the deceased died and before the will was written. She then describes the cafe business at paragraph 11, but my understanding is that is not the basis of the £300 charge. And she says that her personal income from my business as director, and I think that takes in not simply the cafe business, but the two preceding paragraphs, was in excess of £120,000 a year.
So what's her usual professional fees done by reference to? The fees for debt recovery, her fees as a director of the debt recovery company, and or the fees as a practice manager, and or the fees as a cafe owner?
My lord, the evidence which is before you is that which was before the judges below.
Well, that's not correct. There's one of the oddities about the bundle is that it doesn't seem to include the evidence which is quoted by the Deputy Master, paragraph 12 of his judgment, page 66, tab 9, because he refers there to a further witness statement on the 16th of August 2019, and it's that statement that contains the information that your client has been, quote, engaged in business and in the management of commercial and residential property.
Indeed.
And I had understood that that was the foundation for your summary in your skeleton argument. But that particular witness statement, I've been unable to find either in the core bundle or in the supplemental bundle. Maybe I've overlooked it, but I can't find it.
My lord, no, I don't believe you have overlooked it. If I can take a brief pause. I have the appeal bundle from the hearing, from the appeal below. I'll just.
I don't think it need concern you, Mr. Briggs, because the material passage appears to be set out in the judgment. So, while it would be nice for the sake of completeness to have the document that's being quoted from, I don't think it's a massive handicap. But the point remains, as Lord Justice Lewis was asking you, even taking that evidence entirely at face value, the question remains, well, how does that translate into a usual fee?
Indeed, and my lord, I think, without meaning to avoid the question, I think that is really the question for the master on the evidence in assessing what the usual professional or other fee is. The question with which we're concerned today is the principal question: is Ms. Heselton entitled to charge at all? does she even qualify for any remuneration? If she does, then I will invite your lordships to remit the matter back for the master to consider what it is, in fact, is the £300 that she has charged, her usual professional or other fee, or indeed should it be some other fee, or in fact, and I leave it open to my learned friend to argue, as he has hinted at in his skeleton, that she has no usual professional or other fee. That is a matter perfectly within the scope of the master's inquiry when considering the remuneration. But the problem with which we are concerned here is that the deputy master below and indeed the deputy judge below both reached the conclusion that my client did not qualify for remuneration at all.
All right. So we've slightly taken you off your track, which was to construe the clause.
Well, indeed, and my lord,
And you were about to enlighten us as to the history.
well, indeed, my lord, I will do so somewhat briefly. Every charging clause case, as indeed with a great many construction cases, generally need to be dealt with very carefully, because of course they all turn on the specific words that were in front of the judge on the given day. But the reason I refer to this as the chapel extension is because you will find at tab 2 of the authorities manual, the case of chapel decided by Mr. Justice Kay, as he then was. And at the bottom of the first page of the report, there are the words that were in use in that case. I expressly direct that he shall, notwithstanding his exceptions of the office of trustee and executor of this of my will, and his acting in the execution thereof, be entitled to make the same professional charges, and to receive the same pecuniary emoluments and remuneration, all business done by him, and all attendances, time and trouble given and bestowed by him, in or about the execution of the trusts and powers of my said will. And it goes on, as if he, not being himself a trustee or executor of, were employed by the trustee or executor. Those were the words with which Mr. Justice Kay was concerned. And we find the judgment of Mr. Justice Kay from page 586, in which he concluded, this is about 6 lines down, he was being invited to find that he was being authorised not only to make and be paid for professional charges in the usual way, but also to make and be paid professional charges for everything which he does either as a solicitor to the executors or in his private capacity of executor. It would require very clear words to induce me to accede to such an application as that. We then turn over the page to 587. The first substantive paragraph. Now, a trustee or executor would not employ and ought not to employ a solicitor to do things which he could properly do himself. And he goes on to find that the charges which are to be raised must be for something in respect of which he has been properly employed. He therefore concluded that the solicitor was not entitled to charge for any matters for which he could not properly have been employed as a solicitor. But helpfully, at the bottom of the page, and you'll see it's been marked in the margin, he then refers to Mr. Wollstonecraft's form, the text with which you may be familiar. That form contains the words, including all business of whatever kind not strictly professional, but which might have been performed or would necessarily have been performed in person by a trustee not being a solicitor. That extension, he says, would have altered his conclusion. And I say, it is exactly that extension, in a slightly adapted and updated form, that has found its way into this will. Now, Mr. Justice Kay was then elevated to the Court of Appeal, where he sat in the case of Reef Fish, which appears in tab 3 of your authorities bundle. And this is the only Court of Appeal authority on the question of these clauses. It is also, interestingly, the last decided case to which will be referred today, which was actually opposed. The wording in that case, in Re Fish, was similar. You'll find it at the bottom of the first page. And I declare the said H.C. Gosnell and every other person thereafter to be hereafter appointed a trustee of my will, who may be a solicitor and professionally employed in matters relating to the trust of my will, shall be entitled, and is hereby authorised to retain and receive out of the trust premises, his usual professional costs and charges, as well as by way of remuneration for business transacted by him, or his partners, etc., and then in parentheses, including all business of whatever kind not strictly professional, but which might have been performed or would necessarily have been performed in person by a trustee not being a solicitor. Again, the chapel extension, or perhaps might be Mr. Wolstenholme's extension. Their lordships considered the ambit of that, but I think it's useful to look briefly at the discussion at page 418 between counsel for the beneficiaries, in which they argued that Harbin and Derby, earlier authority, shows that a power to a solicitor trustee to charge professional services does not entitle him to charge for what a trustee, not a solicitor, could do personally. Lord Justice Kay intervenes that Mr. Wolstenholme's form was intended to avoid that decision. I say that is right. And he refers back to Re Ames, which was also quoted in the Chapel case. They argue that that was distinguished and not followed. And then in answer, it is argued by counsel for the beneficiaries, the words professionally employed in the present case override the whole clause, and the whole power given to him is in terms to retain out of the estate his usual professional costs and charges. Essentially, the argument being made is that he may only charge for matters for which he would raise a usual professional cost or charge. Very much akin to the argument raised by my learned friend in this case, and indeed the position adopted by the Deputy Judge below. If we then turn on to the judgment of Lord Justice Lindley first, giving the new judgment to page 420. And I have marked in the margin the relevant part. The argument, he recites the argument made against him, that Mr. Gosnell should have a £200 legacy for his trouble and only at liberty to charge for his professional costs. He says this, but the will does not say that. He recites what indeed the will might have said, and concludes at the bottom of that paragraph, he is entitled to charge not only for his professional services, but for his trouble as a trustee, and also to have his legacy. Lord Justice Bowen reaches the same conclusion. I don't need to read you the reasons, but it's instructive to look at the conclusion of Lord Justice Kay, of course, barely 5 years after his decision in Chapel, at page 424, the second substantive paragraph. Describes this as a point of very general practical interest, in the form suggested in Mr. Wolstenholme in his precedents, giving the solicitor trustee power not only to charge professional costs for professional business done by him as solicitor to the trust, but giving him power also to charge for all business done by him in his character of trustee. Turning over the page, he says, I do not at all compliment the frame of the clause, for I admit that some of its language affords grounds for such contention, but still, judging of it fairly, I do not think that contention is well founded. I think that the meaning and intention of the clause is to give the solicitor trustee power not only to charge for work which is the proper work of a solicitor done for a client, but also to charge for work which he would be bound to do as a trustee, or which he might do as a trustee, and would not properly be solicitor's work, although as though it were professional. So, my lord, the Chapel extension, if I can refer to that, is specifically included so that work which would not ordinarily fall within the course of business of a solicitor may nevertheless be charged. and I say it applies equally in this case to a professional, even if the work that they do on behalf of the estate is not within the ordinary course of their business. Pausing briefly before I touch on the rest of the authorities, it may be helpful just to consider a perfectly routine example. At the very outset of the administration of an estate, one of the first tasks to be done by an executor is to gather together the deceased's papers, documents, correspondence, emails usually, and from those papers to identify his assets, what accounts he has with utility providers, businesses, stockbrokers, etc., any of the above, and therefore to from then to contact those providers to inform them of the fact of the deceased's death and to ascertain what his assets or liabilities were as at the date of death. It's an absolutely essential part of the estate administration. And it's often, in fact, a very time-consuming and tedious task. It is not necessarily one requiring an enormous amount of skill, but it does require a great deal of time. Now that, unless you work in the business of estate administration specifically, is almost certainly well outside your scope of ordinary expertise. For an accountant, for an investment advisor, for any number of other professionals whose remuneration would not ordinarily be considered contentious in this context, that is nevertheless a task which requires to be undertaken. What my learned friend's argument, and indeed the judgment of the judge below, would seem to indicate is that because that is not work for which a fee would usually be charged, i.e. there is no usual professional fee, it is not work for which any professional business person is entitled to be remunerated unless they are in the business of trust administration and estate administration. That, I say, is wholly unappealing and will have a dramatic consequence, if it is right, dramatic consequence on whether professional or other persons are willing to accept the role of executor. Because if essentially the very first task that they have to do in the job is one for which they're not going to be paid, that will very quickly elicit whether or not they're willing to act gratis. So there is a good reason why these clauses are included. Now, moving on to the relatively recent days of 1896, the case of Clarkson and Robinson, upon which the judge below and my learned friend placed considerable reliance. I have two comments about this case first. I mean, the first obviously is that it needs to be considered on its own particular facts, because of course it dealt with different clauses in different terms. But it also carries with it an unusual feature, which is also true of the Wertheimer decision, and indeed Orwell's trusts, which is that there wasn't in fact an argument on both sides. Curiously, Clarkson and Robinson, there were leading and junior counsel for the trustees seeking approval of their fees and remuneration, leading and junior counsel for the adult beneficiaries who did not oppose the remuneration, and junior counsel for the minors and unborns who also did not oppose the remuneration, in the face of which Mr. Justice Buckley refused to approve the remuneration. He did so very much in the face of everyone in front of him. It is nevertheless instructive to go through in some detail how he reached that conclusion. The wording of the clause is at the bottom of the first page of the report, and it does include, I don't think I need to read it out, but it does include the words whether in the ordinary course of his professional business or not, and although not of a nature strictly requiring the employment of a solicitor or other professional person. I think a variation on the clauses that we've seen before. Mr. Justice Buckley begins his judgment at page 724, and the relevant passage is on page 725, about 9 lines down, where he says, "It appears to me that under this clause, you must see whether the work done is done in the profession or in the business of the trustee or executor who is seeking to charge for it. And if it be work done in the course of that business, then notwithstanding that he is a trustee or executor, he is entitled to the charge usual in his profession, if it be a profession, or usual in his business, if it be a business. You are not to see whether the work has been done in the ordinary course of his profession or business." That is the distinction that Mr. Justice Buckley draws between the course of the business and the ordinary course of the business. And on that basis, he concludes that although the work was not done in the ordinary course of business, it was done in the course of business and therefore chargeable. What he goes on to find at the bottom of that page, however...
Well, before you go on, would you accept or dispute that the reasoning thus far is equally applicable to the present clause?
My Lord, I don't think the reasoning is applicable to the present case. Firstly, because the wording crucially is different on this, thus far.
Well, what's the critical difference in wording between this clause and the clause that we have?
So, my Lord, the critical difference is actually the one that he identifies at the bottom of the page, which is that in this case, the trustee is entitled to be remunerated for work or business outside the ordinary course of his profession and work or business which he could or should have done personally had he not been in any professional
That's the
business.
second part of the clause, the caveat, which corresponds, you say, or is said to correspond to the caveat in this case.
Exactly.
But it's the opening words, it's the trustee, all usual professional fees. That's the bit that starts off by describing, on one analysis, which groups of people can charge at all.
Yes, I mean, you're right that it's a... forgive me, I'm just reminding myself of the wording. It's a person engaged in any professional business. And to that extent, I think it's as wide as our...
This clause. And to be paid all usual professional or other charges. We've got professional or other fees. But
yes, indeed.
To
and I think to that extent...
And what he's saying is that part of the clause presupposes that somebody is in a business for which there are usual professional fees relating to the management of estate.
Well, I think that is where Mr. Justice, well, certainly where this case can be distinguished. As I said earlier, you cannot have a usual professional fee for work that falls outside the ordinary scope of your business.
That's the second bit, but we're focusing on the first bit. If you're not in the first bit, on one analysis, if you're not in a business or profession at all for which it's usual to charge estate management related fees, then you don't get through the gateway of the clause.
Well,
you can't look at the caveat and get into the main part by saying, well, I can't go through the gateway, but I'm going to climb over the wall.
Well, my Lord, I think that is where the learned judge below fell into error. I say the clause, you have to construe the clause as a whole. And to say that there are, a person in business may have a usual professional or other fee, even if their professional business has no relation to estate administration at all. My learned friend takes me up and says, well, by this logic, a dentist can charge. And I don't shy away from it. I say a dentist has a usual professional or other fee. And if doing work in the administration of the estate, is entitled to be remunerated. So I do take it that far.
Can I go back to my Lord Justice Lewis's question, which is what is the difference in wording that you rely on between the clause Mr. Justice Buckley was faced with and our clause? Because both of them, there are large amounts of similarity. Both of them refer to any profession or business. In his case, it was any trustee or executor being a solicitor or other person engaged in any professional business, and ours is any of my trustees who may be engaged in professional business. Both of them refer to usual, professional, or other. In his case, usual, professional, or other charges, and in our case, usual, professional, and other fees. And both of them have the two extensions at the end, whether in the ordinary course of his professional business or not. Ours is including work or business outside the ordinary course of his profession. And although not of a nature strictly requiring the employment of a solicitor or other professional person, ours is and work or business which he could or should have done personally had he not been in any professional business.
Well,
so there are large similarities.
There are, man.
So what is the verbal distinction? I mean, you can say two things. You can say every case turns on its own wording, which is obviously true. You can say that this wording is to be distinguished, or you can say that Mr. Justice Buckley was wrong. By it.
Although I do say Mr. Justice Buckley was wrong.
Right.
I certainly do say that.
But that's a second. Do you say on the wording is materially different?
My lord, I think I think in practical terms that you're right that they are very similar. The wording, although not of a nature strictly requiring the employment of a solicitor or other professional person, is, I think, somewhat narrower than work or business which he could or should have done professionally had he not been in any professional business. I think that is slightly narrower. I think that would justify a distinction. And indeed, Mr. Justice Buckley does, at the bottom of page 725, distinguish the case of Refished, which I've already taken, because that case, in his view, included the material words, including all business of whatever kind not strictly professional, but which might have been performed or would necessarily have been performed in person by a trustee not being a solicitor. Now, I think, frankly, that the difference in wording is not that substantial. I think the reality is that Mr. Justice Buckley was simply wrong in his conclusion as to the proper construction of the clause. But if you're not with me, in that conclusion, the case is certainly capable of distinction.
Thank you.
So, my lord, as far as Clarkson and Robinson goes, I say it can be constrained to its own facts, but in any case, it is certainly not binding in this court. I say the learned judge below wrongly adopted that reason. And I want to tackle head-on the point made by the learned judge below and also raised by Mr. Justice Buckley in this case. Why, he asks rhetorically, should a person not engaged in a professional business be precluded from charging at all? But a person engaged in any professional business, however unrelated to estate administration, be entitled to charge for everything? And that is, I think that it is a fair question to ask, but I think there is also a fair answer. Somewhat in two parts. The flippant part might simply be to say because that's what the law says. But I think the more substantive point, which is also raised in argument before the Court of Appeal in Fish, is that if a person is engaged in a professional business, their time is their time can be attributed a value, and their work can be attributed a value. If a person is not engaged in any professional business, either they are, as the case is often referred to, simply a gentleman, or indeed a person of leisure if they are retired, if for any other reason they are simply not so engaged, it is very difficult, may even be impossible, to ascribe to their time and their work a value. The purpose of the clause, rather than simply saying charge £200 an hour, is so that the value to be ascribed to their time can be drawn from their usual professional or other fees.
Compared to the flat fee of £300, sorry. The flat fee of £300 a month, as I understand, irrespective of the time taken.
My lord, the charge of £300 a month was for I think both work done and time taken, it was essentially a flat fee. And as I
Variable whether she did any work or not for that month.
well, I don't think that was how it was put in the evidence. I think that the most germane part of the estate administration was the management of the property which was let, and it was the rental income from which those fees were then drawn. So essentially, it was a charge for property management. Sorry, my lord, you also had a question.
I'm trying to remember what it was.
Sorry.
Yes, no, it was this. I know what it is to be engaged in a profession. Does engaged in a business include employees? You may say we don't need to answer that. But I'm just seeing how far your rationale goes. For some senior employees, their time is very important. But one wouldn't normally say they were engaged in business. You'd normally say they were employees of a business.
Indeed, I think it would be a mistake to try and delineate exactly the scope of any professional business. I think it will have to be a question to be answered on the particular facts of each case. I do say that an employee is capable of being engaged in business, and indeed many persons who even set up on their own may be the employee of a company of which they are themselves a shareholder. I think it would be wrong to exclude employees as an entire class. But I think really the purpose of that requirement is to ascertain whether they have any usual professional or other fees. That's the way in which that is the way in which I would delineate it.
So, do I understand from your submissions that you're saying this is really all about the opportunity cost to the individual in question?
I think it could be described in those terms. Yes, ma'am. I think the underlying justification is that the time of a professional or a business person has value in and of itself. And that is something for which they should be compensated, because they have spent that time administering the estate when, ex hypothesi, they could have spent it in their profession or otherwise in remunerative being engaged in something for which they would be remunerated.
One can understand the rationale for that approach, but that would tend to exclude employees because, of course, they don't suffer the opportunity cost their employer does.
No, I suppose, well, it would depend whether they were doing the work during their working hours or outside of it. But I suppose, yes, I can see the difficulty in as you describe, if they have not taken, as long as they haven't taken unpaid leave in order to do this work. I suppose it's more easily applicable to someone who charges an hourly rate. And of course, most of these clauses were drafted very much with solicitors, accountants, professionals in mind, but also intended to cover a wide scope. I think it's instructive that actually in the Clarkson and Robertson case, the executors who were appointed were Mr. Clarkson, architect, Mr. Goddard, a gentleman, a chartered accountant, another gentleman, and a solicitor. It may take a wide scope of abilities and indeed professional expertise to administer a complex estate.
And you will say it's the second question, whether or not Mrs. Heselton has a usual monthly fee of £300 for whichever the business is, the cafe, the debt management, or the practice manager.
Indeed.
That'll be, you say, the next stage to ask whether she has any usual fee, and if so, it's £300 a month.
Exactly. My lords, I don't think that there is much that I can add to the conversation by taking you through the facts of Re Wertheimer and Re Orwell. Both of those concerned individuals with very specialist expertise, not pertaining to estate administration, but who were nevertheless remunerated and authorised to be remunerated out of the estate.
Yes,
and work that they have done.
Just a small question on that. I don't think it much matters for the reasons you've just identified. But in the case of Wertheimer,
Yes.
We don't seem to have the actual judgment.
Forgive me, my lord.
Is that because it's unavailable?
That was simply an oversight by my clerk. I have the report.
Thank you.
I brought spare copies if I can hand these up.
Yes, indeed.
Again, as I said earlier, Wertheimer was a case in which remuneration was not opposed by any of the parties. The same was true of Orwell. You'll see from the report there is a fairly lengthy summary of the discussion. We have the terms of the clause on the second page of the report. But the reasons given for the judgment are contained in the single paragraph at the bottom of page 338. He was satisfied that the defendant was carrying on a professional business within the meaning of the clause of the will.
Yeah. That, and I think Orwell, again, was an example of a case where it was in the exercise of his professional business that he was providing services.
It was certainly, and both. I think Orwell is a slightly unusual one because, Wertheimer is a slightly unusual one because the individual concerned was an art valuation expert.
Yes.
And so he provided the valuation services, which I think might have been said to pertain to his ordinary course of business. Of course, the fact that he charged a percentage fee, the report doesn't really enlighten us as to whether that would usually be how he would charge fees for valuation work, or whether in fact that was something more bespoke that was arrived at between the parties. I think that is something on which we can only speculate. I can imagine it being something of a conflict of interest if a valuer's fee related to the value they ascribed to the item.
All right. And is it worth looking at Orwell briefly?
My lord, I don't propose to take you through Orwell. I don't think that it adds anything more to the discussion. And likewise, I don't propose to take your lordships to either the Jersey or the Guernsey authorities that are included within the bundle. I've included them simply by way of indication to show that the approach taken in those jurisdictions is a relatively open and, if I may say, liberal one as to remuneration. And
it's a rather different point, though, isn't it? It's the court has power. It's Duke of Norfolk's trusts. The court has power to authorise remuneration to ensure that trusts and estates are properly administered, and particularly in places like Jersey and Guernsey, if you want professional people to do a job, you have to pay them.
Well, exactly, and I think the point that was made in Duke of Norfolk's is that it's about good administration. It's about the value. It's about the value to the testator of having someone with expertise or who can apply.
But in a way, I mean, actually, I think these cases don't help us at all. But it could be said that these cases are against you because what they illustrate is that what you want in administering a trust is someone with relevant expertise. And paying somebody who has irrelevant expertise because they're a professional or business person in a completely different context is something different. But so that's why I say they don't really help you. But I don't think they really assist us.
No, my lord, and I don't propose to take it any further than that. I think, well, I suppose really the point here is that, as you say, we are concerned with the testatrix and her freedom of testation.
Yes.
And she may choose, if she does not authorize, we all agree, if she does not authorize remuneration, remuneration, then the
And
court,
none is payable. No.
exactly, the court may have a separate jurisdiction to authorise it, but only, as you say, if there is particular value in expertise. That is not the test that we're concerned with. We're simply concerned with whether this testatrix authorised this executor. And we cannot overlook the fact that the deceased chose Sandra Heselton to be her executor, knowing what her business interests were, knowing what her experience was.
How does that
And
happen?
provided
Because
for
the
her to
judge
be-
found that it wasn't adapted to the facts of her case. She presumably chose Mrs. Heselton because she trusted her. Whether or not she can be paid has nothing to do with that.
But I don't think we can say that she, the testatrix chose Miss Heselton, but overlooked or ignored the fact that she was entitled to be remunerated. She also chose to provide for remuneration for her executors.
In certain circumstances. The question is, do the circumstances arise?
Indeed.
So I don't quite see how those assist.
It would be very surprising, in my submission, if she had appointed, if she had appointed Miss Heselton and Mr. Arnold, providing for professionals to be remunerated, but not intending that clause to apply to the executors that she had chosen.
Do we know whether Mr. Armour was engaged in a professional business?
He was a solicitor.
Yes,
wasn't
I think he was, not in this jurisdiction.
He was the solicitor of Dominica.
Yes, indeed, he was the solicitor of Dominica.
I think it's very difficult to draw any inferences as to the testatrix's attention from these facts that she appointed Miss Heselton and Mr. Armour, because you don't know whether she had in mind Mr. Armour or whether she had in mind Miss Heselton. We just have to construe the clause as it stands.
Indeed.
She, in fact, left legacies to both of them, so one simply doesn't know whether she thought that was adequate compensation for their time and trouble. It seems to me to be a speculation. We can't really go into.
I will move on, my lord. My lord, I think then that concludes my primary argument on the first ground of appeal. I say it is really, we begin and end with the construction of the relevant clause. I do want, however, just to address the language of the Trustee Act, because I say that the conclusion reached by the learned judge below renders the charging clause effectively odious, because there is a vanishingly small category of individuals who would fall within that clause, but who would not, in any event, be entitled to be remunerated under the 2000 Act. The 2000 Act had come into force shortly before the will was drafted, your lordships may already be familiar with Section 28. Section 28 provides that where a trustee acts in a professional capacity, and the trust instrument authorises his remuneration, he is entitled to be remunerated for services, even if they are services which are capable of being provided by a lay trustee, which, in respect of those doing estate administration, has, if I may say, codified the chattel extension into law. But of course, it only applies where the trustee acts in a professional capacity. And that is a professional business which consists of or includes the provision of services in connection with management and administration of trusts, or any particular aspect of the management or administration of trust generally, or a particular kind of trust, and the services he provides to or on behalf of the trust fall within that description. Now that is unnervingly close to the formulation adopted by the judge below. The judge below was of the view that a trustee could only be remunerated under clause if there was a usual professional or other fee, i.e. if this was a service in connection with the administration of the estate, which would, for which they would charge an ordinary fee. So that means they need to be engaged in a professional business, which at least includes an aspect of the management or administration of trusts and estates. Now, if they do...
Well, is that right? So take something that's a little bit analogous to Wertheim, but a bit different. So let's take the case of an executor who happens to be a builder. He's in business, or she is in business as a builder. And some repair is needed to property forming part of the estate. Whether to sell it or rent it doesn't matter. So the builder does the work. So you have someone who is an executor and a builder, and therefore will have a usual fee for work of that sort. Now, on the judge's interpretation, that would be covered, would it not? But it wouldn't necessarily be covered by Section 28, would it?
No, my lord. I think you've astutely identified what is I think quite a narrow category of individuals. But yes, I'd agree with you. I think the point still stands that the judge's formulation is alarmingly close to.
But why does that matter? If somebody wants to put it in a will, and I don't know what the law is, whether there's provisions about probate in Dominica and so on, that they wanted to be sure that whatever happened, these things were covered. Or they might have said, I don't care what the law is, it might be repealed for all I know. I'm going to put it in the will. Why does the fact that something might also be covered by statute in some way influence the interpretation of what they've put in the will? I don't see it at the moment.
Well, my lord, I think the Dominican angle is an unusual one in this case, but I would say that if there are two possible constructions of a clause, and one of them is nearly identical to the situation which pertains under the ordinary law anyway, and the other is something in addition, I think it's fair to infer that the testatrix must have intended to add to the ordinary position under the law rather than simply to mirror it. The beginning of the clause is that the trustees and executors will have these powers in addition to their ordinary powers under the law. So I think it's a fair inference to say that and I appreciate I'm coming back to the point my Lord Justice Nugee raised earlier, that we are speculating somewhat about the testatrix's intentions. But I do say that the construction that's been put on the clause by the learned judge below appears to be more informed by the framework of Section
I can understand the point in the abstract, but how does it work in circumstances where we know that this is a clause taken from a precedent and the precedent long predates the 2000 Act?
I think even though it comes from precedent, I think we have to assume that the testatrix has, at least to some extent, chosen which parts of the precedent to adopt and which not. Every precedent has clauses which may or may not be included, and every will is bespoke, one hopes. So the fact that the testatrix, or indeed her advisor, has chosen to include a clause at a time when this act had come into force, and when at least her advisor is taken to have known the fact, must indicate that it is intended to expand upon that rather than simply to mirror it. And I say that it does. I say that it carries the logic of Section 28 far beyond, well, simply to professions and businesses beyond those relating to trust administration.
Can I ask?
Please.
I mean, I entirely understand the way you put it, which is that given that this is the general law, if you put something else in, you assume that it's intended to do something more. One possible answer is whoever drafted it wasn't actually aware of Section 28, but put that on one side. But what Section 28 requires is that there is a provision in the trust instrument entitling the trustee to receive payment out of trust funds in respect of services. So you still have to put a charging clause in to attract Section 28. What's the purpose of Section 28 then?
Actually, the real purpose of Section 28 is to provide the chapel extension and to codify the chapel extension. It is so that if you are entitled to, if the charging clause in the will permits you to be remunerated, you may be remunerated, and this is you may be remunerated for work even if those are work capable of, even if it is work capable of being provided by a lay trustee. That is what Section 28 changed or codified, if you will.
But it doesn't apply to the extent to which a trust instrument makes inconsistent provision. So
that is true.
So if you had a trust instrument which said you could be charged for strictly professional work only, you wouldn't get the chapel extension. I mean, it does seem very odd to say you have to have a charging clause, and if it's inconsistent, this doesn't apply. So the only charging clause to which it does apply is one which is consistent with it. I mean, it's a bit of an odd way of drafting. I don't think we need to pursue this. I see the way in which you put it, which is, given Section 28, you would expect this charging clause to do something more.
Indeed. And I say that actually the other point is that the exercise that my Lord Justice Lewis has referred to several times, that the master has to go through, or whoever the taxing master may be, in ascertaining whether this is a person engaged in professional business, whether they've done work on behalf of the estate, and what the usual professional or other fee is, in my submission, going to be rendered a great deal more difficult if the master is wrestling with the question of whether this is work done in the course of the professional business, but not necessarily within the ordinary scope of a professional business. That, I say, is really a distinction.
That's not what he has to do. He has to ask whether this is, the first question he has to ask is, if the judge is right, is whether this is work done in the course of a business. If the person isn't doing a business which involves estate management, then it doesn't arise. Thereafter, there's an extension. Even if the particular item of work isn't part of that usual business, you can still get it. But the fact that you've got a problem at the second stage, I'm not yet convinced helps you in deciding whether or not you're in through the first stage. As I say, it's the gateway versus the climbing in over the wall.
Well, indeed, but I think, my lord, that as I say, I don't think that can be squared with, I think, asking the question, well, has this been done in the course of the professional business? When you're actually looking at someone has done something, they are charging for something. And if that something is, on the wording of the clause, quite properly something outside the ordinary course of their business.
If the only thing that's been done is outside the person's normal business or profession, that's the end of it. There's nothing in the court. That's an extension, but you've got to be in the first part first, haven't you?
I know, my lord. I think that is simply where we part company.
Okay.
Is that
you've got to take it as a whole, and it's not the first part and the second part. There are two equal limbs, and provide you in either limb, that's enough.
And I say it is a very straightforward series of three questions.
Yeah.
You ask, firstly, is this a person engaged in any professional business? You ask, secondly, have they done work or spent time in connection with the administration of the estate? And if they have, they're entitled to charge their usual professional and other fees, or indeed to retain brokerage, commission, so on and so forth. And I say that the additional requirement that usual professional or other fee must be for the particular work that they've done in relation to the estate is a gloss that the clause simply doesn't contain.
And the usual fees are the fees that they charge for their business, which might be unconnected. So if they were Bitcoin entrepreneurs charging $1 million a day, because that's what Bitcoin entrepreneurs do, that's what they charge under this.
Well, my lord, I think there will have to be a degree of common sense in the application.
No, but that is what the clause says. If it's the usual fees of the business of the person who is the executor, if the usual fee is low, then so be it. If it's £300 a month, so be it. But if Miss Heselton happened to be a Bitcoin entrepreneur charging £1 million a day, that would be the usual fee, wouldn't it?
I think
Your
that would-
analysis of the clause.
yes, I think that would be the usual fee. I would add that there is, and this isn't the subject of today, but there is an established right for beneficiaries to have trustees' remuneration moderated.
But the key thing is you said the words usual fee attached to the business that the executor does and is not limiting the scope of the business which falls within the scope of the charging clause.
Precisely.
Yes.
My Lords, unless I can assist you further on the first ground of appeal, I propose to deal very briefly with the second ground, which is in the alternative. And for that, I'm afraid I do need to take you back to the judgment of the Deputy Master, which you will find behind tab 9 in the appeal. The Deputy Master at paragraph 10 of his judgment at page 64 says, so that is the ambit of the charging clause. The question is whether Mrs. Heselton has satisfied me that she was conducting a business and her activities in administering the estate for the period that she was an executor were done in the course of that business. That is the question that the Deputy Master was asking himself. And he concluded he was not satisfied that she was conducting a business and denied her the remuneration. The Deputy Judge applied a different test, and we find this in tab 5, right at the end of the judgment. Paragraph 45, page 39, paragraph 45. He describes, the Deputy Master concluded that on the evidence he was not satisfied that Mrs. Heselton's activities in administering the deceased estate were done in the course of the business that she had identified. Given the extremely limited information that Mrs. Heselton chose to provide to the court about her business and about the work that she carried out, his conclusion seems to me amply justified. However, what the Deputy Judge failed to consider was that, of course, he had applied a different test, which is at paragraph 10 of his judgment. Forgive me, I think I just need to find the right paragraph.
GB 30, perhaps?
Yes, my lord, I think really paragraph 30 taken with paragraph 44 sums up the Deputy Judge's conclusion. These words govern not just the amount of the fee that could be charged, but the nature of the work for which a fee may be charged. And then he goes on to say, at paragraph 44, I conclude that a trustee or executor can rely upon the charging clause in the will to charge for work done or time spent in the administration of the estate, only if that work falls within the scope of their professional business in question. That is to say, if it is work of a type which would attract or incur their usual professional fees. My only point on the second ground of appeal, and I take it briefly, is that the Deputy Judge did not address his mind to whether on his analysis, which is a different one to the Deputy Master's, on his analysis, Mrs. Heselton's evidence was capable of satisfying that test. He declined to interfere with the Deputy Master's conclusion below, saying that his conclusion, but of course the Deputy Master was applying a different test. If your Lordships are not with me on the first ground of appeal, I invite you to refer the matter back for the Master applying the test arrived at by the learned judge to consider whether, as Lord Justice Lewis has indicated, whether the evidence satisfies that test, the test arrived at by the learned deputy judge.
Can I just ask you, you said more than once that deputy judge applied a different test to the deputy master. I take the deputy master's test, which I think you did, from paragraph 10 on page 64. The question is whether Mrs. Heselton has satisfied me that she was conducting a business and her activities in administering the estate for the period which she was an executor were done in the course of that business. That's the deputy master's test. And then I look at the deputy judge's judgment, and having gone through the analysis, he concludes at paragraph 44 on page 39. I conclude that a trustee or executor can rely upon the charging clause in the will to charge for work done or time spent in the administration of the estate only if that work falls within the scope of their professional business in question. Now, it's true he goes on to say, that is to say, there's a usual charge. Just stopping there at that semicolon, in what respect is that test different from the deputy master's test? And both of them seem to say, what's the executor's business or profession? What's the work they've done? Is it done in the course of that business, as the deputy master's wording, falls within the scope of their professional business as the deputy judge's wording? What's the difference?
I do say there is a difference, my lord, because what the Deputy Master was asking himself is whether Miss Heselton was conducting a business and her activities in administering the estate were in the course of that business. Whereas actually what the Deputy Judge seemed to be asking himself is whether this was work which would attract a usual or other fee.
Well, 44, only if that work falls within the scope of their professional business in question. That seems to be the same.
The two are similar. I think it's really that the Deputy Judge is asking, as it were, the additional question: is it work of a type which would attract a usual professional fee? But I understand the point that's made, which is that if both judges are satisfied that Miss Heselton wasn't acting in the course of the business at all, then there is no point going on to the second stage. But I think really the point on the second ground of appeal is that the Deputy Judge hasn't actually applied his mind.
Yeah. So you emphasise in paragraph 44 the words "that is to say."
Yes. Because
what you're submitting is that he's there qualifying work falls within the scope of their professional business. And that, he goes on to say that is to say if his work type which would attract or incur their usual professional fees. So that's what you're placing reliance on.
Indeed.
I see.
My lords, I don't think I need to address you on the third ground of appeal, which is the question of costs. If you're with me on the first ground of appeal, the second, then I think the usual cost consequences will follow. I don't understand when I'm going to take any particular objection on that point. Unless I can assist your lordships in further. Oh, may I turn my back for a moment?
Indeed.
Thank you.
Thank you, Mr. Mitchell.
professional charging clause, however it is particularly drafted, is not an opportunity clause. It cannot avail an important person to come along and say, I'm an important person, I'm a professional, I'm a business person, and so therefore, especially if it's got the chapel extension, I'm going to charge this estate my usual fees. I think the fact that you can only charge usual and professional fees excludes people who are employed but earn an awful lot of money. But it might include, Lord Justice Lewis's example, a Bitcoin trader earning £1 million a day. These clauses have been around for centuries, as Mr. Briggs said, but there's no case upon which an executor has said, well, I'm an important person, please can I have payment relying on a professional charging clause. That is telling. And that is the essence of what the appellant is arguing. Say this clause was so broad that I can charge, and I happen to run a number of different businesses, one of which I may have been a director of the cafe for a short period of time, and so I'm going to ask for that. In relation to her debt recovery business, she wasn't even a director, so I think even on that she wouldn't be entitled to charge. The devil is in the detail on specific clauses, and there is nothing in this clause that entitles the appellant to charge. For that reason, the Deputy Master Lloyd, and the Deputy Judge Rees, were both correct. There are two approaches to the clause. One is a narrow interpretation that was adopted by the Deputy Master, and if I could take on Lord Justice Lewis's description, that would be called the narrow gate. And the Deputy Judge took a slightly broader interpretation, such that there might be activities that are not falling within section 28. And that's a broader interpretation, and that could be called the wider gate. But in either event, you have to get through that gate. And this appellant doesn't. The charging clause actually just reflects section 28. As my Lord said, taken from a precedent, we can't say what was in the intentions of the testatrix at the time, and nor can we say what actually happened to her wills and probate solicitor, and why they put that in at that stage. But it's telling to note that it was just a few short months after the Trustees Act 2000 had come into force. That came into force in February 2001, and this will was signed in June 2001. Mr. Briggs says the will was drafted after the Act came into force, but we don't have any evidence as to when the will was actually drafted. We look at the clause, there is no material difference between that and section 28. The clause as cleaned is at page 30 in the Deputy Judge's judgment at paragraph 11. So the wording is not on all fours, but it is not materially different, we would submit, because it says at the beginning, under clause 11G, for any of my trustees who shall be engaged in any profession or business, and section 28 just says in the course of a profession or business, so there is that change, there is that variation, but it's not material. Then what entitles payment? Payment can only be entitled when the work of the business or profession is in connection with the administration of my estate or the trust powers or provisions of this will. And that is in exactly the same terms as section 28.5. If he acts in a professional capacity, if he acts in the course of a professional business which consists of the provision or services in connection with the management or administration of trust generally, in particular kind of trust, then it goes on to include, unsurprisingly, the chapel extension, including work or business outside the ordinary course of his professional work or business, which he could or should have done personally had he not been in any profession or business. And that mirrors section 28.2. The trustee is to be treated as entitled under the trust instrument to receive payment in respect of services, even if they are services which are capable of being provided by him as a lay trustee.
So I'm a little bit puzzled because on the one hand you told us that the judge's interpretation went slightly beyond section 28. Now you're submitting that actually there's no difference.
Yes.
So which is it? Because you don't have any respondent's notice saying that the judge got it wrong.
The judge, I don't think the judge materially extended the gate or widened the gate. And that can be seen by looking at, as we just did, paragraph 44 of his judgment and then paragraph 10 of the Deputy Master's judgment. And you can see from my skeleton argument that I say exactly this at the paragraph 6 and 7, that this clause is exactly akin to section 28, and that is the way that it was approached by both the Deputy Master and the Deputy Judge. And the only difference is a fuller consideration of how do the cases of re Orwell and re Wytherner fit in within that.
Just to make this a little bit more concrete, what do you say about the builder example that I put to Mr. Briggs? So he accepted that that would be covered by the judge's construction, but not by section 28. Do you agree or disagree with that?
I agree that the judge's interpretation is broader, and that if a builder is providing a service of utility to the estate, then that could be charged for. I think the better view is the one that the Deputy Master took.
I haven't quite understood what the difference is between what the view the Deputy Master took and the view the Deputy Judge took.
The Deputy Judge's view could, in theory, incorporate an example like a builder.
Why could the Deputy Master's view not incorporate that? What he said in paragraph 10 was, you have to ask, is the executor engaged in a professional business?
Yes.
Yes, he's a builder, that's a business.
Yes.
Were his activities in administering the estate done in the course of that business? Well, repairing the trust property may not technically be part of administering the estate, but it's services to the estate done in the course of the business. Were you saying the Deputy Master wouldn't allow the builder to charge a profit cost?
Well, I think he was using administer the estate in the way it is used under Section 28, and that these are, and in those circumstances, it wouldn't cover a builder. A builder, his business is not in the administration of estates.
But the way, I mean, it may not matter, but the way in which the Deputy Masters phrased that sentence may just reflect the fact that what Mrs. Heselton was trying to charge for were her activities in administering the estate.
Perhaps, but I think he was because he says further up at paragraph 8.
Yes, I see. Business has to have some relevance to the matter of administering estates. The administration time spent should have been part and parcel of that business.
And that's completely at one with Section 28 and the interpretation of Section 28.
All right, can I ask a different question? Because so far we've been debating with you two questions. One is whether there's a difference of view between the Deputy Master and the Deputy Judge. Secondly, the extent to which, if at all, the clause goes wider than Section 28. But can I ask you a different question, because it relates to your opening observation? And again, take my builder example.
Yes.
Regardless of whether that would be covered by Section 28 or not, given the wording of the clause, what would be the purpose, on a purposive interpretation of the clause, why should the builder not be entitled to charge? Because as I think you've accepted, on my hypothetical example, it's a value to the estate. Moreover, the person providing the service is in the business of providing that service. Why on earth should that not be covered by the clause purposively interpreted?
It would be.
Right.
And that is why the cases where there's a service to the estate have been allowed to charge. The Re Orwell example and the Re Wertheimer example. But in fact, if we will look at those in more detail, and you'll see that there was actually provision in the Re Orwell case, for example. Mr. Justice Weinrock decided that the executors extended to the literary executors. So undertaking work as the literary executor of the Blair literary heritage was part of the administration of the estate, and so fell within the professional clause in charge.
Yeah, so just to summarise that in my own words, to be clear that I've understood it. I mean, Wertheimer and Orwell are a little bit different in the sense that you could categorise the individuals involved in those cases as professionals.
Yes.
Whereas in the builder example, that is someone one would normally regard as a professional. But as I understand it, you're accepting that doesn't matter because the clause in front of us explicitly includes any business as distinct from profession, and a builder is in business.
Yes, that's correct. That's slightly different to the point I was making about Re Orwell, which is that under Re Orwell, that interpretation by Mr. Justice Weinrock meant that the literary executor was performing steps in the administration of the estate, because the estate included the literary estate as well.
Ah, yes. I'm sorry. I missed that point, but I take your point.
So,
but why is that a material distinction? I appreciate, of course, it's a stronger case from the point of view of the person seeking to charge. Plainly, if they're doing steps which are part of the administration of the state and falling within their professional capacity, as in that example, then that's a stronger case. But going back to the builder example, as I think you've accepted, that's a service which is of value to the estate, even if it's not actually part of the administration of the estate.
yes, that's correct, but that's on the wider interpretation of the deputy judge.
Yes.
On the Re Orwell falls within both the wide gate and the narrow gate. It gets through the narrow gate because that they were an executor in the administration of the estate. And it's really only Re Wertheimer that is one where there's a bit of uncertainty about whether or not that particular executor would get through a standard professional charging clause. The wording on that will was very precise, and it says that, of course, a testator or testatrix can put anything in to say, like Lord Justice Arnold says, if you're a professional business person, you can charge this estate, and not qualify it by saying in the administration of the estate. And so the builder would be able to charge regardless of whether they had a utility to the estate. In Re Wertheimer, the precise clause said any of my executors that are doing business in the premises can charge me or charge the estate. And the expert had to go to the property and was dealing with all the art held at that specific property, so fell within the specific clause entitling payment.
Well, there are activities that are related to the realisation in the best possible manner of the assets comprising the estate.
Yes.
And it's the builder who improves the house, it's the planning consultant who gets an extension, or it's the art expert who gets the best sale of the assets at the highest price because he knows the people in the business. All of those are concerned with the administration of the estate in the very broad sense.
In the very broad sense.
Maximising the value of the assets of the estate.
Correct, in the broad sense, not in the narrow sense.
Of doing the bits and paper that says where the accounts are and which utilities
yes,
must be
under the specific criterion of Section 28, which the appellant accepts she doesn't satisfy, and I'll take you to that as well.
And
but
in connection with, you've got broad words to start with, as well as the administration of the estate may not just be the paper documents, but the administration of the estate getting in the assets in the most preferable way possible.
yes, and I'll just read instead of taking you to this clause, because the clause in Re Wertheimer means that it was a specific clause. Let's not worry about the professional charging elements of it, but it was a specific clause that allowed the executors to charge when they were doing business in the premises. So it didn't qualify in the course of, or in connection with, or in relation to the administration of the estate. And if we turn to the report, which is at tab 5, please, or you have the proper copies now, you can see what the testator granted at the top of page 338. Employ Messrs. Christie, Messrs. Woods, etc., etc. And then it says, the testator further declared that any executor or trustee for the time being of his will, being a solicitor or other person engaged in any professional business, pausing there, it doesn't then say in connection with the administration of the estate or in relation to the administration of the estate. So it's extremely broad. Should be entitled to charge and be paid all usual professional and other charges for any business done by him in the premises, whether or not in the ordinary course of business or not. And then Mr. Justice Neville at the bottom said that this man was providing a professional business within the meaning of the clause of this will. He was an expert and provided a service. So he qualified it. I mean, I think on the terms of the will, there wasn't any particular qualification that if the executor was conducting a business in the premises, they'd be entitled to charge.
What do you say premises means? Does that mean the property?
Yeah.
Doesn't in the premises mean in the administration of my estate? Isn't it in the trusts which I've imposed on you? It seems very odd that you should be limited to charging if your business is done.
Yes, you might be right, actually, my lord.
And what the judge says at the end is he's
Yes.
given very useful and valuable services to his colleagues in the course of the administration of the estate.
Yes, you might be right. I perhaps have got confused because all his art was contained in his private residence. And perhaps that...
The premises mean the selling of the artwork, I think.
My lord, I think Lord Justice
Yeah.
Nugee's interpretation is correct, is in the premises of what you're doing in relation to
Yeah.
your role as the executor.
But
And
there's a trust for sale, and one of the things that needs to be done is sell the art. And there's a discussion as to how you sell the art and whether you put it up for auction. And they decide to go by private treaty, and he charges a commission in and about that. So it is all in and about what they've been charged with doing, which is selling the art collection.
Yeah.
Yes, that's correct. It's unusual. It's a bit removed from the usual administration of the estate, but I think it falls within it predates real well, but it falls within that interpretation of the administration of the estate, and I think that falls.
Trustee Act have a definition of the administration of the estate, or is it to a chancery lawyer obvious? Every chancery lawyer knows what that is from birth.
Yes, and if they didn't, they've got the assistance of Lewin on trusts, which is in the bundle at tab 9, my lords, where it explains at paragraph 2024, which is on page 850, going on to 851. What type of person falls within 28 as
Well, that wasn't quite Lord Justice Lewis's question, which is there a statutory definition of administration of estates? I don't recall any, but that doesn't mean to say that one doesn't exist.
yes, sorry.
And if there's no statutory definition, is there any established definition in equity?
There's no, I'm not aware of any statutory definition. And then looking at section 28 and the understanding of it's distilled down in Lewin, it says at the end of paragraph page 851, going on to 852, a person engaged in a professional business which does not pertain to management or administration of trusts at all will fall outside of the definition of a trustee acting in a professional capacity. And so in this respect, the definition of 2000 Act is narrower than in the class of some charging clauses. So the view is there that if you're in a professional capacity, it's very narrow in relation to the administration of estates, and it's accepted by the appellant that she wouldn't fall within that. That's set out at page 34 of the judgment. When looking at this section, which is at paragraph 24, section 28 reverses the general rule that a trustee is not entitled to remuneration in relation to trust corporations and trustees who are acting in a professional capacity. Then the subsection is referenced, and it says underneath it's common ground that Mrs. Heselton was not acting in a professional capacity within the meaning of this section and cannot rely on this section as entitling her to charge for her work as a trustee. So it's agreed that the appellant doesn't fall within that category. Whatever the reasons why this clause was included within the will, it doesn't go beyond section 28, the narrow interpretation. At that stage, the testatrix had options. She could have included a broad clause, and a broader clause is the clause that's used in the encyclopedia, which is not qualified with the administration of state. For example, she could have been partial to business people and decide that if a business person is going to be a trustee of her will, that they could charge under such a clause. But there'd be no point, because it really would be unworkable, because anyone, as was noted by the deputy judge, anyone could set up a business to be able to qualify. It's much better, as she did, to give specific legacies to her executors. Or she could have had specific terms, like was done in Re Orwell, to include the administration of the literary estate within the estate generally. There are no cases where a person, executor, just happens to be a business person, and they've been able to utilise this type of clause to charge profit costs for time spent on estate matters. The broader interpretation, well, is there anything in this particular clause under this will that goes beyond section 28? It's not said by the appellant how this clause does extend beyond section 28. But if the words of the clause "in connection with the administration of my estate" means more than section 28, it must mean a business that is of some utility to the estate, which is why the examples given by Lord Justice Arnold fall within this category. A car dealer may well be a business person, but cannot use this clause unless the estate needs to sell a car. A plumber cannot use plumbing works unless needed on an estate property. A dentist won't be able to get through the broad interpretation. Very difficult to see what a dentist could do with their skills to assist in the administration or in connection with the administration of the estate. Can an employee assert that they are a business person? No, because they do not charge usual professional fees. They have a salary. So it's only...
Yeah, but that's a slightly different point. So let's take the example of the dentist.
Yeah.
Because Mr. Briggs accepted that he, on his argument, the dentist would be entitled to charge. And you say, and I understand this very clearly, you say, well, that's plainly not covered by this kind of clause. It's not designed to cover the opportunity cost unless the business is of utility to the estate. I understand that submission. But what I would like to be clear about is what words you say exclude the dentist. What words in the clause exclude the dentist?
In connection with.
But the dentist says, I've spent lots of time
Yes.
getting together the papers, identifying the assets,
Yes.
realising the assets. Why is that not work done in connection with the administration of the estate?
Because none of that is work that he does or he or she does as a dentist. So
I think you accept it is work done in the administration of the estate.
yes, but
But
it's,
you say, when it says, and this is what the judge said, all usual professional and other fees, it means the fees that you, as a dentist, would usually charge for work of that type.
exactly.
And,
So
So it's
and
those
the
words.
dentist wouldn't usually charge for work of that type.
Yeah,
So,
exactly.
so to be crystal clear, you are supporting the judge's construction of the clause that the key to it, for our purposes, is all usual, professional and other fees.
Yes, but I think the key words are, and also in connection with the administration of the estate.
Well, that's the bit I'm not understanding. I can understand your reliance upon all usual, professional and other fees. I get that point, but I don't understand why you say it's of assistance then to read on in connection with the administration of my estate, given the hypothesis is that the individual in question is actually doing work in the administration of the estate.
Because I think if you didn't read it as a whole, it might be argued by the appellant, well, these are my usual in business professional fees. That's just taken in the abstract. I happen to run a business that's got no utility to the estate whatsoever, but look at the clause. It says I'm allowed to charge all usual, professional and other fees. So I think it has to be read in the context of that being a service that's in connection with the administration of my estate, which is why the dentist example wouldn't work, but the trustee example works, the solicitor works, and you get some quite niche specialities that assist the estate. A chartered surveyor, perhaps, or in the case law, a literary executor and a person who can value art. Has a real utility to the administration of the estate. Dental work doesn't. Dentist charges usual and professional fees. So that, I think that's why it needs to be read as a whole.
May I ask another problem that's currently troubling me, or do you need to make further submissions on the matter we're dealing? Is it convenient to go off on a different topic now?
I hope I don't need to make more submissions on that.
If we're dealing with my Lord's builder's example, he repairs the house so it can be sold in order to realise the assets. So that is work that's caught by the first part of the clause. He's in through the gateway.
Yes.
And he can charge the fees that he would normally charge.
Yes.
For building. But does that then mean if he does anything else as well, sorting out the utility bills and so on, he can get that separate set of work by relying on the N words. He's got into the clause because he's doing work to improve the building for its sale, and then anything else he does, even though if he hadn't had to do any building work at all,
yes,
on your analysis, he wouldn't have been able to get fees. But does he get the fees?
Yes, he gets the fees. He's a lucky builder.
He's a lucky builder.
He's a
if
lucky
the house
builder.
was in perfect condition, he wouldn't have. But because he's got to do something, or it's a plumber and the house has sprung a leak and he fixes it, then the clause is intended to allow him not just to get the building work,
Yeah.
but to get money for doing paperwork that he would not otherwise have been able to charge under the clause.
Yes, and for one primary reason, that the clause in this will doesn't just say including work or business outside the ordinary course of his profession or work or business, because then that's the distinction between ordinary work and unordinary work, but you're still acting with your business hat on. Mm. It goes on to say, or should have done personally, and had he not been in any professional business. So that added bit enables him to take off his builder's hat, hard hat, or take off his business hat and say, well, I'm a lay executor, but look at the terms of the will, it's broad enough to include me. Of course, the executors between themselves often will say, well, I'm not going to allow, I'll do that, because you're going to charge the estate for that, but I'm a standard lay executor, so I'll do all that work to avoid the depletion of the estate. But he's a lucky builder. Once you're through Gateway 1, you can utilise the full extent of whatever is the a caveated clause, and this one is quite broad because it says you can do anything personally. But what you can't do is jump over the fence and get to that without going through the gate. So the builder can be lucky if his work is needed, but the dentist can never be a lucky dentist. They can't jump over the fence and get to this broad clause. And there's just no case law that has ever suggested that. Here, the appellant was a director of the French Art Cafe for a few years towards the end of her period when she was executor, but no fees were charged to the estate by the French Art Cafe or the appellant as a director of that cafe. And if they had been charged, they wouldn't have got through the gateway.
Those services are unconnected with this property. Neither of the two flats in Dominica, as far as we're aware, nor the flat in London was used for the display of artwork. So I don't think we need to worry about that.
It was just never in connection with. So she just doesn't get over the first hurdle or through that gate. She needed to be wearing a business hat, and that hat needed to have had some benefit to the estate, and she was not. And even if she was wearing a business hat, it wouldn't have been a hat that they grabbed. So we would submit, in fact, if you look at this clause carefully, it doesn't go anywhere beyond section 28, and the master correctly took that view, and the appeal should be dismissed. But if the clause does go further, the business service must be of some utility to the estate, must be in connection with the administration of the estate, even if it's not narrowly defined. But the appellant here provided no such services, and she didn't charge the estate. So the deputy judge was also correct to dismiss the first appeal, and this second appeal should also be dismissed. Those are my submissions, unless there are any specific questions from the Lord.
Did you want to say anything on ground 2?
Yeah, I think ground 2, he applied the test correctly to the evidence he had in front of him, and there was no evidence at all that she'd done anything, or any of these businesses had been in connection with the administration of the estate.
There was some very scanty evidence. She said she'd been involved in collecting and managing, collecting rent and managing properties.
She did say that.
Why can't she charge a fee for doing the same thing?
Because there was no evidence before the court that was in any way a utility to the estate.
So she wasn't actually managing.
I don't think she was.
She was just charging £300.
Yes, I think there were agents involved. I can't remember exactly, but there was no evidence that she had actually managed this property, nor was there any evidence that she had charged such fees to the estate. What happened was there was an account to be directed. This was a case where she was removed as the executor. She then went into the property and claimed that she had a lien exercised over the property, but the possession proceedings were brought against her successfully. And then she was required to give an account. And then in the course of this, she said, here's the rent, £48,000, and I've been entitled to charge a standing fee of £300 per month. Roughly 43,000.
Is that paragraph 4 at page 63?
Yes. That's why the master got it correct in paragraph 10 in combination with paragraph 40.
So she charged a fee, you say, in this judgment, but it wasn't connected with the doing of anything for the property. It was just a deduction
Yes,
every month.
yes.
So she wasn't somebody, even if she was involved with managing property at some stage in
Well-
England, it wasn't something she'd done in...
Her explanation of what the fee was is set out by the Deputy Master at the foot of page 65. This is towards the end of paragraph 10 of his judgment. And he quotes paragraph 12 of her statement saying the flat fee of £300 which I charged was inclusive of all work transacted on behalf of the estate to include all legal costs incurred by my company to Heselton solicitors who were operating under my company's retainer. All that firm's costs were paid on an indemnity basis.
Yes, again, that begs so many questions because what was her company that was instructing her husband's solicitor's firm? And there was no evidence of any charges from Heselton solicitors to the estate, but they would be separate.
They would get those anyway, as I
Yeah,
understand it,
exactly.
yes.
And under the order of a Deputy Master, I think that's still to be determined whether there's any expenses as
Correct.
opposed to profit costs.
Exactly, and we've accepted the whole way through that she'd be entitled to that.
As long as they're proper charges.
Yeah.
But that inquiry's not yet happened.
Correct.
Yeah. The question, as the Deputy Master puts it at paragraph 11, what I'm concerned with is whether she's entitled to charge what solicitors would call profit costs for use of her time. That's the question.
Correct. My lords, unless there are any other further questions. Those are my submissions.
No, thank you.
My lord, I'll be brief. I think it is easy after two appeals to criticise the quality of the evidence that was adduced as not addressing the correct test. Of course, at the time when her statements were prepared, Ms. Heselton was blithely unaware of the minute detail into which the court would now be going in scrutinising this clause and how it is to be analysed. Nevertheless, she has given evidence that she had debt recovery companies. She doesn't say whether they are as shareholder or as director, and that also, as Lord Arnold identified earlier, she has been engaged in business and in the management of commercial and residential property since before Ms. Townsend made her will. The cafe is a complete red herring. It began in 2014. The estate had been in administration for a long time before that, so that you can safely ignore.
I do find it a bit surprising that if you're making a witness statement and your obligation is to tell the truth, the whole truth, and nothing but the truth, but I'm not a chancery person, the world may be different. I just don't understand why you don't say between 1992 and 2014, I was involved with property management. I ran 6 companies. I ran six coastal properties, renting them out each month. That's what I did here. I made sure the properties were staffed and let and so on. I just don't know why you don't say that.
My lord, nor do I.
Oh, right.
I'm afraid I don't have any better answer for you
Then
than
you've
that.
given right.
The
Okay.
evidence is, I'm afraid,
That's as it
exactly
is, and we've just got to
it
take
is
it
as
as it is.
as it
Yep.
is.
Okay.
There is nothing I can do to it.
Yep.
My lord, Lord Lewis asked the question: well, is there a statutory definition of the administration of the estate? You'll notice, of course, that actually Section 28 of the 2000 Act is framed exclusively in relation to trusts, but under Section 35 it also applies to personal representatives, so we have to do a little bit of fitting a square peg into a round hole. I would direct your lordship to Section 25 of the Administration of Estates Act 1925, which prescribes the duties of a personal representative and what is necessary in order to complete the administration. And finally, my Lord, I think really I come back to the question of the lucky builder. It cannot be the correct construction of this clause that it is simply a question of luck whether this person's expertise happened to be called upon at some stage in the administration, and therefore retrospectively they're entitled to be remunerated for everything that they've done prior, or not. That I'm afraid is incoherent. It has also been, and I think my learned friend hinted at this, that the clause is open to abuse. That it might be open to someone to simply start a business and then claim, or claim to be a Bitcoin entrepreneur. I think the first point is that the masters are perfectly capable of identifying such abuse and addressing it as and when it needs to be addressed. But I suppose I would also make the point that the statutory provision under Section 28 is equally open to such an abuse, at least in theory, but it is not one that militates against the construction for which I have argued. My Lords, I don't propose to say anything further.
Very good. Thank you both for your helpful and concise submissions. Given that this clause is so widely used, clearly we need to consider carefully how it should properly be interpreted. We will therefore be reserving our judgments. We will adopt the standard practice in this court of sending out the judgments in draft before they are formally and publicly handed down. That is in order that counsel may correct our typographical errors and any obvious factual misapprehensions, not to re-argue the case. And as I'm sure counsel will be both aware, the practice is that takes place under embargo, and the embargo must be strictly observed. We hope that once you have got the draft judgment, you will be able to agree the consequential order. If by mischance you are unable to agree it in whole or in part, please put in brief written submissions as to the points as to which you are disagreed.